Welcome to our roundtable on UNCITRAL Working Group III, Investor State Dispute Settlement Reform. My name is Yari Krivoy. I am Director of the Investment Treaty Forum, and I'm also Senior Fellow in International Economic Law here at the British Institute of International and Comparative Law. For those of you who join us for the first time, the British Institute of International and Comparative Law is an independent charity based in London, and the Investment Treaty Forum is a part of this institute in charge of international investment law. So we do investor-state disputes, we do treaty work, we conduct empirical studies, we also organize various events, including two bigger events in spring and in autumn, as well as a number of smaller events, most of which are hosted by members of the Investment Treaty Forum, who are big and small international law firms. International law, I mean those firms which are doing international law. Some of them have foreign offices, some of them don't. We also have senior practitioners, academics as individual members. We also have consultative members, various governments and intergovernmental organizations who do not pay for their membership, but they make important contribution to the forum in other ways. This event will be run using similar logistical arrangements as other ITF events. So we will record this roundtable for the benefit of those ITF members who are unable to join us tonight. The recording will not be available publicly, but it will be available for ITF members in the members only zone. Also, we plan to have a blog post written about this event with a summary of the most important and most interesting thoughts expressed at this event. And if we decide to quote you, then we will ask for your permission. Otherwise, we'll just not quote people in this blog. The format of this event is as follows. So first, we will have introductory remarks from Shane Spellacy, who actually chairs the UNCITRAL Working Group III on Investor-State Dispute Settlement Reform. And usually he's somewhere high on the podium, very far from ordinary representatives of governments, intergovernmental organizations, and NGOs. But tonight we're very fortunate to have Shane not far, but sitting next to us around this round table. And hearing his thoughts on the progress of the UNCITRAL Working Group III. It usually meets in Vienna and in New York, where representatives of various governments come together. But recently, various states started hosting smaller events within their own jurisdiction, to say so, focusing on particular aspects of UNCITRAL Working Group III work. So after the initial remarks of Shane, I will also invite others to make their remarks either on specific issues which we raised in the event description or on the process more generally. I would like to ask you to keep your remarks fairly brief, 3, maybe maximum 5 minutes, so that we have an interactive format. And in order for those who are online, if you want to speak, please raise your virtual hand first, because I will need to unmute you. And the reason for this is that if we do not unmute everyone, then it interferes with video. Someone forgot to unmute himself or herself, and then we see this person on the screen rather than the panelists. So just raise your hand, and then I will be able to unmute you, and then you can either make your own contribution or speak or ask your question. People are still joining us online. There are a few seats. Feel free to occupy those two. Maybe you want to sit a bit closer here, so empty on both sides. So with that, let me invite Shane to say a few words about what the UNCITRAL Working Group III is, what it has already managed to achieve, what challenges it's facing, and also what are the future plans and future outputs which you hope to see.
Thank you, Jarek, and thanks to BIICL for organizing this and giving me really the opportunity to come and speak here in a more informal fashion, where it's not up on the dais and there's not flags raised. These sort of forum are very useful to hear feedback and ideas outside of the specific UNCITRAL context. So to give just a little bit of background on where we are, I think it's important to situate ourselves sort of in the broader environment here. I think it's likely safe to say that we're the most significant period for the reform of ISDS mechanisms that we have ever really gone through as an international community. This is not to say that there haven't been efforts at reforms, or bilaterally, plurilaterally, states have done this. My state, Canada, of course, has been involved in a number of sort of modernizations throughout the years, whether it's been through NAFTA, through CETA, CPTPP. That is happening. Multilaterally, we have seen it. Of course, we just have the recent success of the ICSID reforms that have come to the procedural rules. So there are efforts going on in this space, but at least to my mind, the UNCITRAL process is probably the most comprehensive and wide-reaching of all of those processes in what it is trying to achieve in what might seem like a long period of time. We've been at this since 2017, but in the multilateral negotiation context, that really is the blink of an eye when you have 100 states trying to be involved. So I know when I see and I recognize many familiar faces, so a lot of you know about UNCITRAL, but let me just give sort of a 2-minute overview for those who aren't as familiar. UNCITRAL is the core legal body of the United Nations system in the field of international trade law. There are other bodies in the UN that are in this space. UNCTAD is there from a policy development for trade that operates in the space. But UNCITRAL is the one who is the core legal and legislative body in the system. It has officially 70 member states who are members of UNCITRAL, representing all regions of the world. But in reality, at least in Working Group 3, participation is much broader than that. Any member state of the UN is entitled to be an observer at UNCITRAL. In practice, there's no real difference between observers and member states, in the sense that when a state's flag goes up, they can be called upon and recognized, and we don't deal with members first and then observers. Observers participate just as frequently as members. There aren't many differences. The only time that membership really does come to matter is if there is ever a vote, and that happens very, very rarely at UNCITRAL. Decisions are in fact taken by consensus. Now, it is a body of the United Nations General Assembly, so it does have the capacity to vote. But UNCITRAL really does try to decide by getting everybody to agree. And I think, in understanding how that works, well, it does mean that progress can be slow sometimes. We have to ensure that no state is left behind, but I also see that consensus process as sort of a great leveler amongst member states. Because we see consensus, UNCITRAL really is a place where all states, whether it is a big state or a small state, capital importing, capital exporting, in the process of developing or developed, that all states have an equal voice. And I think that is extremely important for the project that we are engaged upon right now, where you have stakeholders representing so many different aspects, whether they are typically respondent states, whether they are typically states that are home states of investors, all have the same voice in UNCITRAL. We do have very strong participation. It is typically over 100 states, typically around 110 who participate in Working Group 3. That is far more than most working groups at UNCITRAL. It is almost entirely government representatives who come to participate for states. That is also a little bit unusual in UNCITRAL, where in the history, in the past, it has been delegates who have been from private firms asked to come and represent states because they are dealing with highly technical areas. This was very early on recognized as not only technical, but also high policy. And so typically governments are represented by government officials. That does not mean that there isn't participation of others, NGOs, IGOs, investor groups, civil society, academic groups, bar associations. They are all invited to come. The process for accreditation to the working group is one that is run by the Secretariat, not by me. So don't ask if you can come. I don't have that power. But there are rules, and I know from the Secretariat that the interest in Working Group 3 is such that they have to say no, that there are a number of people who wish to attend and they simply do not have the space or capacity. When things went online, it was much easier. They simply said, yes, but you can only watch online. Now with the budget situation at the UN no longer allowing for online broadcasting, that has ceased as of now, and I know that has caused some angst for those who no longer can follow along live. The meetings are still posted. You can go view the meetings. The reports are posted publicly. They do strive for transparency, but that broadcasting is sort of going to reduce participation. Let's come briefly to what the working group is doing. So back, as I said, in 2017, the commission, which is sort of the overseeing body of the working group, tasked the working group with a three-part mandate. That was to identify the concerns with investor-state dispute settlement, to determine whether those concerns warranted reforms, and if they did, to design and bring those reforms to the commission for approval. The mandate is, in its own wording, a broad mandate, but it is limited to investor-state dispute settlement. That has been a tricky issue for sure in the working group as to what does that mean. As I have understood it, the easiest way is that the commission did not mandate the working group to reform the substantive standards of investment protection. So while it can consider things related to dispute settlement, such as procedural rules, such as methods of dispute settlement, what it has not been asked to do is to try to clarify what the FET standard means or what indirect expropriation means. Those are the substantive standards. There's a lot of gray after that. That has led to a lot of debate in the working group as to what is substance that would be outside, what is actually related to dispute settlement in general, and we try to work through those things to see what we can do, noting that we are to have a broad mandate. There's concern, of course, by a number, and we've heard this a lot from developing states as well as some NGOs, that even though it is a broad mandate on investor-state dispute settlement, it is in fact too limited, that we need to address those issues of the meaning of the standards, because that is the problem. There is, I would suggest everyone, a practicality to a limited mandate. There is only so much that is in fact manageable as a task. But that, of course, does not mean that it's not important for states to start thinking about what the balance is in their investment agreements, whether they've achieved that appropriate balance, are they happy with their substantive standards? And I know other work is going on in other organizations about that. OECD has a group tasked with looking at some of the standards, and states are doing that as well. So that's the broad mandate. But as I said, it's a huge, if you think about that, all right, so we've got 3,000 treaties, dispute settlement, so let's just reform them. How do you start? How do you do that? And that took actually a lot of discussion because states were not added on how to do that. There were a number who wanted to focus on structural reform, such as the creation of a permanent investment system. There are others who questioned that and said what we need to do is work more on reforms to the existing system, things like the code of conduct, procedural rules. The compromise that was reached early on was that we would move forward on a number of reforms simultaneously, trying to find a balance between structural reforms and non-structural reforms. So this is why, if you look at our report, you might think, gosh, they're jumping around quite a bit. You know, like they're doing 2 days on the development of investment court and then 3 days on, on a code of conduct. And the next time they come back and they're talking about third-party funding. You know, they need some focus here. That is the result of a compromise where we're trying to move things all forward simultaneously. To do that, we have a number of streams that we develop, work streams. They're big buckets that we're trying to have things in. We had one on ADR and mediation. We had others, the second one was on the development of a code of conduct. The third was the creation of an advisory center. The fourth is the development of specific procedural rules to address concerns like frivolous claims, third-party funding, security for costs, broader issues, right to regulate, counterclaims have been raised as well. And then we had structural reforms, which is the development of a standing multilateral investment court, as well as a separate stream on the development of an appellate mechanism. So those were our substantive streams. We have been developing those reforms now for several years. And just last year, we had 4 specific reforms approved by the Commission. So the Code of Conduct for arbitrators, Code of Conduct for judges in the nascent permanent international investment court, draft provisions on mediation, and draft guidelines for the mediation of investment disputes. That was done last year. This year, coming up in June and July, we are taking, as a working group, we are taking to the Commission for approval, in principle, the creation of a multilateral advisory center. So we have a statute that we have drafted, agreement was reached on that statute. There are still some things that will need to be put into operation. The big questions, of course, for an advisory center is who will fund it? How much money will it have? This is a bit of a chicken and an egg problem because you don't know how much the center can do until you know how much money it will have, and you don't know how much money it'll have until it has members, but you can't have members until you have a statute. And so we are trying to move forward in bits, approval in principle of the statute, and then there will be a meeting, one of the ones that Yarak mentioned, sort of not a formal working group meeting, but an intersessional meeting in Thailand in December of this year as we look to try and finalize and operationalize some aspects. We had, after we take that to the Commission this year, we then look to finalize topics such as the procedural rules reforms for 2025. We generally have 3 groups of rules that we have, 3 groupings that we are trying to organize our discussions of. So we have the rules, procedural rules that were just adopted by ICSID, and that can be one basis for our discussions. We then talked about a second grouping, which is what is known as ICSID Plus. So rules that ICSID have where some states might like to do more and develop certain options on those. The ones that stick out so far where some states have raised include things like third-party funding, include things like costs. And then we have rules that are not in ICSID, which would be brand new, and we will have to discuss those from the start. Those would be the procedural rules that have been developed on things like damages, right to regulate. The fact that we've grouped them in this way is not a conclusion of the working group, of course, that we will develop in. This is the way we have grouped them for discussion. I would suggest and hope that, for example, the first grouping, the ICSID rules, where a number of states have already reviewed and agreed, are going to be easier to discuss. The hope is that these are base rules. As we come down there, then they say, okay, well now there's the ICSID Plus. Okay, so these are basic ICSID rules we could have, but do we want to do something else? That gets a little bit more challenging because there can be different viewpoints, some optionality might need to be done there. And then the third bucket where we are negotiating ab initio from scratch, potential rules would probably be the most challenging because now we are into an area where there are not procedural rules and questions will abound as to whether or not we should do anything here. How do we do that? Again, I would suggest success will depend on there being some level of choice for states. We will then have as well, hopefully, I guess it would be 2025, discussion of the creation of a permanent mechanism. We then will turn after that to remaining projects, appellate mechanism, reforms in the terms of arbitrator selection. And then we still have the end project, which is how this all ties together. What we have been doing by moving these forward in streams is creating individual projects, but in the end, we need to find some way to make it all work. And we have generally been referring to this in the working group as a multilateral instrument that could be signed. It has generally been conceived of as some sort of framework convention with protocols attached to it. Now, what we call protocols, annexes, it doesn't matter, but with sort of attachments to it, sort of a hub and spokes model, if you will, where states might have choices as to which protocols they sign up to. And this would allow some sovereign decisions to be made where you could sign up, for example, to the convention you might accept. Therefore, in that convention, the procedural rules reforms, and you might say, what I would like is to have ad hoc ISDS arbitration as a first instance with an appellate mechanism. And that you could then opt into various protocols that would get you that result. There would be others who might say, well, I'd like to have, the procedural rules reform, but a full 2-level investment court, and there would be protocols that you could opt into to get that result. What we are trying to do here is to allow states sort of their choice as to reflect their own experience and reflect their own sovereign decision-making as to what types of reforms are relevant for them, but also hopefully to find some way to create some level of harmonization. UNCITRAL is a body that seeks to harmonize international trade law. I think, it is inevitable in this sphere where there are also already 3,000 treaties that there will be some level of fragmentation here as states will choose different options for themselves. But if we can find a way to agree to enough as the core principles, we can hopefully achieve some level of uniformity or unity to move forward for the group that would be helpful. Of course, there are other ways in which some of the reforms might be used by states even who don't sign a multilateral instrument. They can be considered model clauses, they can be considered guidelines to approach that our work can be open in that regard. So the idea here is to be done by, I guess it would be by the time it's all done at Commission 2027, which would make it a 10-year project, I think, if I'm counting correctly. There's still a lot to be done, and there's still a lot on the agenda for that. It is an ambitious goal, certainly. It's a goal that I still remain optimistic that we can reach. Without a doubt, when we were planning it all out in 2017, we didn't put 2.5 years of international pandemic in the middle of it. That wasn't really thought about as we had to go online, and that slowed things down, but we are trying to use a lot of the tools we have that Derek mentioned, these informal meetings, to try to further advance the working of the working group. You can't make decisions at informal meetings, but you can at least prep the ground so that when you get into the room, that can hopefully move a little bit faster. So that's hopefully where we've been, why we're here, and I'll leave it at that so that we can sort of engage.
Thank you very much. I particularly like the idea of an informal meeting in Thailand in December 2024.
We're slices of it. We're slices of it.
Take that one. So we have actually around 10 governments attending this event, not only the UK government, but also various governments attending us online. But I think what makes this event different from other events we should attend is the presence of big law firms which do work both for governments and for private investors, right? So and it's some firms specialized, they are only doing state law work primarily, but most firms they do both. And maybe the thoughts and ideas expressed here would be of interest. But let me ask you one question. As a chair as the chair of the UNCITRAL Working Group III, what are the main challenges? So my own observations when I attended several times the meetings of the UNCITRAL Working Group III in Vienna, I saw that there was a sort of a split between some groups of states. I saw that developed and developing countries may not necessarily be on the same page on some issues. I mean, capital importing and capital exporting countries. I also thought that those states which had a lot of experience with investor-state dispute settlement, they have slightly different perception of issues, of what is important, how to address them, than those states which either had no experience or which are maybe facing their first claim ever. I haven't seen that much of a disagreement between views expressed, well, actually, I think there is as well, between, let's say, views expressed by business groups, there are some business groups in the room as well, and states. And some states are also supposed to act or in accordance with their government's mandate to promote, let's say, external investments. And so they may overlap, but you can see a difference between those who are capital investors and states. Are there any other not really contradictions, but groups or types of interests which you have to balance if you want to make progress? Because I understand it can be quite tricky because all those constituencies they have their own views, but you need to make progress with those complex issues.
Yeah, I think UNCITRAL Working Group III is interesting in that regard because there are splits between states, but they don't often fall on the traditional ones. I'm not sure that actually I would agree necessarily that there's a split between necessarily developed states and developing states. I see a lot of actually different lived experiences from states in this context, which contributes to them thinking in a particular way. And so, you can look at, and oftentimes in other UNCITRAL bodies, you might get developed states or like-minded states who line up on a particular issue. Here, some of the more fundamental differences are between those states who otherwise might be considered like-minded states as to what the most appropriate reforms are to address some of the concerns. I think one of the interesting things at UNCITRAL is, and in our work was, there was consensus that there are concerns with ISDS. There was consensus that reform is needed. At the beginning, there were a number of states talking about structural reform and incremental reform. Those who didn't favor structural reform, though, didn't like the word incremental reform because it seemed to them to minimize the concerns that they had, and that they also shared serious concerns about the way ISDS was being done. There was a consensus really on the need for a deep and real meaningful reform. Where you start to get then the splits between the groups is based upon how they have experienced ISDS. And I do think that that's more interesting. So oftentimes you will get, if you take sort of OECD or G7 countries, very different points of view as to what sort of reforms are sort of the best approach. You will see those differences and those splits as well in least developed countries, depending upon what their experience has been. So I think that that's quite interesting, and there are several sort of groups that have formed on key main issues, such as, do we want an investment court or not? The lines there, I think, there are those who feel that that is the way to go. There are those who are not interested in that. There's a large group in the middle that are willing to listen and to think about it, but are constantly emphasizing we have not made any decisions. Those groupings haven't really changed very much over the years. But on other issues, there seems to be a lot more ebb and flow. And I think the really sort of the driving factor from that is what has been your state's experience with ISDS. And I think you are right to say, look, the states who have experience, and particularly lots of experience, do have a different perspective on some of these than the states who might never have faced a claim themselves. Might have had investors bring claims, but that doesn't necessarily translate to a lot of knowledge for the government officials themselves. In terms of the the sort of the other challenges, look, I mean, whenever you get 110 states in the room, let's say 2 or 3 lawyers per delegation, you've now got 300 lawyers trying to draft. One can imagine what sort of, challenge that is, UNCITRAL will spend quite some time arguing about the particular word that might be used here, or whether, the comma should go there and what the impact on meaning is. So that is in of itself. Another interesting one that I found over the course is actually the difference between those who have common law training versus those who have civil law training, and the difference in perspective towards how much should be left to tribunals versus how much should be prescribed. And, typically, not always, but typically a lot of the common law lawyers are much more willing to allow more to be left to the discretion, and the tribunals can develop their own rules. Whereas oftentimes, and it's not just civil law, but where they have more of a prescriptive approach among some. I think too, that does come down to experience. So if you've had particular challenges with, ISDS, you generally want to see a rule that addresses those challenges. You can look at the treaties themselves, right? I mean, you've gone from having the first OECD treaty, a paragraph on ISDS that basically says ISDS, to now whole chapters with 25 articles just on ISDS procedure. That develops over time. So that's also sort of a divide, not just common law, civil law, but a lot of the the states who haven't had much experience, tribunals can figure that out, versus states who have said, well, no, we want a specific rule on that. So I think, whenever you get that many viewpoints, that many experiences in a room, that is where you begin to sort of to move slowly. The other thing is just, this is highly political. Anytime states have to spend money in damages awards, that puts a very different spin and a very different perspective for those states on the decisions that will be made here. It is a technical area, but it is one that often, you see, or governments will see in the newspapers at home. And I know there was, just a referendum in Ecuador on ISDS. I mean, like, this is a super technical area of international dispute settlement, and it's big enough that it gets into a constitutional referendum in Ecuador. And that just shows you, I mean, part of this all kicked off, of course, with articles written in newspapers like the New York Times, and that this was it's no longer in the specialized. And for those about to work for governments, if it's going to be in the newspapers, all the antenna go up, and as a result, that's going to create challenges. The states are going to be cautious. They're going to want to think through things. That's going to force things to just proceed at a slower pace than some people may like.
Yeah, can I add to that? One more thing to say. When I attended the one in January, was seeing how broader political issues that have nothing to do with ISDS end up kind of coming and playing themselves out when decisions are to be taken, for example, about who should or shouldn't have access to the advisory center. So how often does that happen? In what form?
UNCITRAL is still a body of the United Nations, right? And, in that sense, when governments are showing up, they are showing up to the United Nations, and world events as a result will play out. And the broader geopolitical context can influence what goes on in the room, absolutely. I mean, this is still, while it is technical, this is still a collection of states and governments. And ultimately, when there are broader issues that will generate and move states towards what they can support, what they can't support, in a way. And of course, the world is a difficult place right now, and that brings its all sorts of challenges in a way that if in a body just of experts that's not linked to the UN, that's a different thing. And we will get from time to time ambassadors to the UN or legal advisors showing up to make a political statement, and that's in the nature of it.
I should have added that BIICL is a consultative, not consultative, but called observer organization. So we can attend, and Christoph actually went recently on behalf of BIICL. Usually I went in the past to Vienna, not to New York. At the advisory centers, it looks like there is enough consensus for it to happen, right? And it's quite realistic that we will see it happen. Is that right?
I think there's always been consensus that it's a good development, that there is always a lot of support for this. The challenges faced by least developed countries and developing countries in defending these claims, in building capacity, has led to this, with there being a broad support for this. The challenge, as with any of this, will be in the end the funding of it.
Yeah.
And there are many international ideas that have been recognized as good ideas, but when push comes to shove, there needs to be money behind it.
Yeah.
That is what we want to see.
Some states are happy to host it, right? And I think Armenia expressed desire. You are here not in the capacity of representing Armenia, but if you have any other thoughts on the process or.
Yes, with pleasure. Thank you, Yarek. And my name is Arman Sarvarian. I am of the University of Surrey and also an associate at Albertsons here in London. As Yarek mentioned, I've served since 2019, 2020 as delegate and external legal advisor to the Republic of Armenia in UNCITRAL Working Group III. Before that, I was also in the same capacity at BIICL amendment process that resulted in the 2022 arbitration rules and other instruments to which Shane alluded. I should also mention I served in the same capacity at the Legal Committee of the UN General Assembly and other bodies, and so my perspective is somewhat, I actually sit to Shane's right, the bottom right, so my perspective in the physical and in the metaphysical sense is informed by that comparison. In that sense, I'm rather overall rather positive about Working Group 3 in general, about how it functions and how we got here. Certainly relative to some other bodies in which I've been involved, the politics are there, but they are different. And overall, to my impression, they are healthier, rather more technical. There are disagreements. You will have 300 lawyers in a room who are debating about phraseology and other wonderful topics like that. But as a drafting exercise, and yes, in the background there are background interests, and one can. I mean, for my part, I usually have my laptop will have a web page with UNCTAD's database open with some delegation making an intervention. And I just remind myself, oh, what's been recently happened? It's so informative. I'll have the recent arbitration was pending what was settled. As Shane mentioned, so much of a perspective is informed, in my experience or my interpretation, by a single case, or frequently a single case. And that's not a development, that crosses developing lines. Now, Armenia is a low middle income developing state, according to the World Bank's. We had this question of terminology in the context of the advisory center, some rather lengthy discussions about this. The real question to my mind is actually, I remember a very interesting intervention or proposal being made on the advisory center to this effect. How do you really define a state that ought to have priority of access to the services of the advisory center? They did proposals on lines of experience. And I thought, well, I mean, at one level, that's quite pertinent. I can think of multiple developed states that have just been sued for the first time, colleagues of mine, and the reactions are not dissimilar to those of developing states. Hang on now, suddenly we have to think about this, because it's not only a case of our nationals, now we are facing budgetary implications and others, political implications at home. And so, yes, I think that when we think of some of the states in the room that do not have, generally speaking, good relations with one another, and that's dynamic, I see very prominently in other UN fora. Certainly in New York. In Vienna, it's a rather different story. I mean, the disagreements are more technical and more professional, I think, than elsewhere. That being said, the code of conduct, I think it'd be interesting to see right now the application phase of that. An idea perhaps for the Investment Treaty Forum and for the Academic Forum and for others is monitoring the implementation of that, because that is now it's in the hands of users, it's a user-driven document. There's certainly been a lot of public discussion about it. Events such as this, the acid test for that is how it will be used and will it be used. So tracking that would be interesting. The advisory centre, certainly, again, from my perspective, I completely agree with Shane's remarks on this, that the acid test is funding and it's practical questions. Yes, the draft statute is helpful to have, but certainly that's the second major reform, if you like, of mediation that's been delivered. And so now we're at the next phase of that. The challenge that I can see for the next couple of years is time. That's the single biggest enemy I think we have, if I can put it that way. There's just limited time. As Shane mentioned, there's a lot on our plate. Take procedural rules reform. I mean, we are facing, I think, we have theatre session meetings very helpful. It's now a selection process to some extent, and there are different preferences and different priorities, and getting balance to that to present the next major reform will be a question. The exit amendment process helps in that respect. That fact completes that, but as Shane mentioned, there are reforms there that have not included. Varying levels of attendance. That's frequently happens, sort of retreading all the ground to some extent, necessarily so. And the last remark I'll make on this is we do have a tendency sometimes to, and to some extent, there's months that have passed in the interim, but we almost forget decisions that were taken at a previous meeting and in limited time. So sometimes it's deja vu, and we're having the same discussion that we had at the last meeting or the one before that. To some extent, that could be, and I can sympathize that some delegations, they need to ensure that people at home know the particular position has been pushed hard. On the other hand, once a certain decision has been taken, I've frequently encountered this. I arrive and I'm prepared on the assumption of the last meeting record, and this is where I am, literally on draft provision, whatever. We've prepared as a delegation on that basis. The discussion then goes in a certain direction. I think, all right, we're having to respond to that. So it is a frustration, but overall, I remain optimistic as to the progress we have made and the progress that we shall hopefully make over the next few years. Thank you.
Thank you very much, Herman. And if there are people who want to contribute or ask a question from the online audience, please raise your virtual hand. Those in the room also feel free to ask questions now or make your own intervention. While you're thinking about your questions, I was wondering what particular procedural issues you have in mind when you say that we hope to make progress with procedural issues soon.
Well, so I think you can go look at the papers. I mean, essentially, there are two different procedural rules that the Secretariat has drafted, almost the idea being an entire sort of this second part of an investment chapter in an FTA rules. Coming down from things like, all the way very procedural things like consolidation, but then also covering a number of the things that are in the ICSID rules, like security of costs, allocation of costs, third-party funding, frivolous claims, reflective loss. So it is quite a broad scope of procedural rules. I agree with Armand. One of the challenges is time on that. We do not have weeks and weeks to go through all of these procedural rules. That's why I think based on what was discussed at the intersessional in Brussels, if the working group can take the decision to basically start from the ICSID rules, that will shave off a lot of work that has to be done, and will provide sort of a viable path forward. If the working group can't come to that conclusion and instead wants to, sort of go through and negotiate these rules, start to finish, that seems like an enormous task, because it is really quite comprehensive. And we're also in the process of looking to say, do we really need a rule on that? And we've already trimmed out some of the original ones that the Secretariat had proposed. The Secretariat, I think, in preparing the first paper they had on procedural rules, really did see it as almost a standalone chapter. They had rules on things like consent to arbitration forum selection, much of which has been stripped away by the working group saying that's for the underlying investment treaty, not for the procedural rules. So we are looking much more something that would be sort of an annex or similar to the UNCITRAL arbitration rules, but just UNCITRAL rules for ISDS. That would be in addition to, and so you will find in there many of the things. I think the controversial ones, or the ones that will be sort of more on the reform point as opposed to modernizing maybe, are going to be things like frivolous claims, third-party funding, damages, allocation of costs, security for costs. These are issues that have been litigated quite frequently in ISDS claims, with results that, as I've heard it from the working group members, not results that are not always satisfactory to states. And so that will be, and ICSID has touched on many of them. And so one of the questions will be, is that for us, is that in the bucket, in the ICSID bucket, where we are dissatisfied that that's the rule? Are there some states who want to try to negotiate some more on that? And I think that that's where sort of the more interesting discussions.
Thank you. Please.
Shay, I'm trying to get my head around how this is all going to work in the grand sort of assembly at the end when you've got this multilateral convention with all sorts of opt-ins, to the extent that this is particularly relevant for the procedural rule. All of the states who will be opting into various parts of the smorgasbord are also in bilateral agreements, often with dozens of other states. And sort of what is the effect of the adoption of a particular suite of procedural rules vis-a-vis those existing conventions? And do they have to enter into a series of bilateral understandings with the various states? And do they even have the scope, to the extent that the other state adopted a different part of the smorgasbord and doesn't agree that suddenly costs should be limited, or awards, as one of the proposals currently is, should be limited to some costs, which is a bit hair-raising for from an investor perspective. So if you're a capital exporting state, you're not going to agree to that. So I'm just wondering how that's supposed to work.
So I think, obviously, from my perspective, I would, want the working group to reach as much consensus as possible on what the procedural rules and the core procedural rules would be, to limit that sort of question of sort of the optionality to the extent possible, where you have to go start doing that puzzle matching, right? That, from the perspective of harmonization, finding consensus on that is the goal. To the extent, though, that there are differences among states that cannot be resolved through consensus, then there is the possibility to create this sort of option, which would then require both states who are parties to the treaty to sign up. And so if state A, let's say there was something on damages, hypothetically. So let's say the working group agreed, damages are within the mandate, they draft something on damages. State A gets not only the basic procedural rules, but also says, I opt into this protocol that includes this clause on damages. Then the partner state, for some of that state's treaties, says yes, and for other partner states, they'll say no. The treaty that does, where both partners haven't agreed to that optional protocol, does not get amended. You need both states to agree. The one that where both states have agreed, then that essentially operates as a new rule in the existing treaty. And so what it does require is consent from both states to anything. Now, the same will apply to all of the rules, of course. Both states will have to sign on. So there could be a state that says, I'd like to sign on this and I take the code of conduct, but I don't like any of the procedural rules. And so if that is an optional protocol, they don't sign on to it. That's something that I would like to try to encourage the working group to avoid, that there should be some basic level of consensus for reform. And the hope is to get that consensus as broad as possible. But there will be, and I think you're right to point out, Chris, that ultimately, if there is too much optionality, what you do get is fragmentation. And you do get a system where you have to be looking to say, okay, this is a treaty, here's this clause, here's what they agreed to, now let me go and try and find, okay, here's a treaty partner and what did they agree to, and are they into paragraph A but not paragraph B? That to me is a challenge. I see it possibly is unavoidable on some, but I would hope to try to minimize the number of ones where you have to do that exercise.
To what extent are you looking at the experience of the protocol on transparency, which had lots of, ins and outs, and we're gonna be part of this, we're part of that, and looking also at the limited number of states that have actually signed and ratified that and saying, okay, let's not, or let's learn from that.
I think, states always consider that. There's also the MLI, or the BEPS convention, as they call it at the OECD, where there is even more optionality, and they actually have a very fancy software program where you can just put in the states and it just spits out the answer. Here's what they've agreed to, here's what the new treaty says. So I mean, there is ways to allow technology to do this. I think, the Mauritius Convention, I don't think the concern is the optionality, that the concern is from some states is simply on the substance of the policy. But I think, this comes down to the importance of moving the discussions at a pace to make sure that we try to achieve as much consensus as possible, and that everybody is comfortable with where we end up, so that when we do get to that end point, they are ready to sign up.
Just to follow up on
And
that.
introduce yourself.
Sorry, Katja Finkel, I'm with Evershed Sutherland. Nice to see everyone. Thanks so much. Just to follow up, how do you envisage this to work with? You mentioned the 3,000 BITs that we're all looking at. How will that interact with the existing ISDS? And then I have a follow-up question, which I'll pose now and then
Sure.
let you have a bit of water, which is on both you and Armand mentioned that a lot of the states will, and we see this in practice as well, they'll be very much informed with their particular experience, right? What do you see? I have a few ideas, and I'm sure others will, but what do you see being those particular issues? Let's put damages aside because that's the biggest one. But are there any, is that what kind of informed the sort of list that you went through of the things to look at? That was the second question. Just the first is
Sure.
How it interacts.
Right, so my understanding, we've had a couple of presentations from this by sort of various public international law experts who've come and spoken to the working group. Is the way that is envisaged, it's a multilateral treaty that will then be used to either add provisions to or amend the existing bilateral treaties between the sides. And so it is the idea behind this is much like the BEPS Convention, much like the Mauritius Convention. The legal construct here is a signal signature on your part can operate to modify your existing treaties as long as the other party signs on to. The reason for this, as opposed to sort of model clauses, is the political reality that going back to renegotiate your existing treaties is not necessarily an easy thing to accomplish. There has to be the political will to do it. Frankly, renegotiating an existing BIT is not quite as sexy as negotiating a new one or negotiating a new FTA. You don't get the same sort of political payoff for the people doing that. Even saying, look, we should go renegotiate a bunch of old treaties which there have never been claims under, just because there might be a claim in the future. Very hard to get the political will to do that. Signal signature, on the other hand, the hope is that you can accomplish a lot with that single signature. So that's the idea on how it will work. In terms of sort of the other ones, yes, damages I think is a very big one that a lot of states have concerns about. There are a lot of states who feel very strongly about this, whether it's even within the mandate or not. These are still discussions to be had. I think in terms of other ones that have influenced where there might be challenges, third-party funding is a big one. Third-party funding in the states that there are a number of states who feel, and so in ICSID context, that feel very strongly about the existence of third-party funding, how third-party funding is used. I would say some of the other ones would include security for costs. And this comes back to the difficulty that states have had in actually recovering costs awards for claims where they've been awarded, but that they haven't, so they end up with an award. And in a lot of cases in investment disputes, it might be a special purpose vehicle and it's just gone and there's no ability to recover. And the standards that they've done. So those are a couple that I think it is very much reflective of the experience that states have had. I think, third-party funding is also an interesting one. Because there is some, for those states who have concerns about it, they have raised things like this is a fundamental shift in who I'm arbitrating with. That I am no longer arbitrating with an investor, but now some sort of financial entity that that doesn't have the same sort of relationship with my country. That's an interesting perspective. I can say certainly it's clear from the working group that it's not entirely shared. There are a number who look and say it shouldn't matter where you're still arbitrating with the investor. That's the investor who is still wrong. But this is one where there have been a lot of strong feelings about it, and it's not new. It goes back, and the discussions were very intense on this in the exit context as well. So I think, but they are really experiences. And some of them are very particular. You know, we've got, you know, experiences where people will raise issues like, you know, like the use of evidence that's illegally collected. This is brought up again and again, consistently by those delegates who have actually had a case. And I don't know how prevalent this problem is. I sort of suspect not all that prevalent. And yet, for those delegations who have actually had a case where this was done and it wasn't resolved in a manner that was satisfactory, this becomes a key touchstone for them, right? And it can be challenging sometimes because for a lot of other states who say, I haven't really ever experienced that, you know, like I get that it's
Part of the
serious for you.
elephant they touched. So.
Yeah, but that, you know, so that is where, as I say, the very particular experiences that states have had in ISDS have really shaped what their touchstones are, what their keystones are in this, and so those are some of the big ones. I mean, I think the other procedural ones, damages, I think, would be one of the most controversial, obviously.
Thank you. And Original, would you like to say a few words? Informed, I imagine, by your work on the LC here on behalf of India, maybe more generally global South.
Thank you. Thank you very much. My name is Aniruddha Rajput. I practice as a consultant here in London and teach international law in Delhi and Vienna. Thank you very much. It's good to know from the person who is overseeing everything. I'm curious what is going to be the fate of counterclaims, because I have found the description fascinating. Every time, every debate, it says it is a very important issue. It needs to be addressed. We're going to come to it, but we're only going to address procedural issues, not substantive issues. So there's no express mention that for us, counterclaims is substantive or procedural, but it's basically a football which is being kicked in every session. That's the impression I get. And that takes me to a slight criticism. Of course, it's not directed against you because there's very little that you can do as the chair of the working group, trying to shepherd as much as you can. But despite that, what I feel, and why I feel there's a contradiction, is the issue of third-party funding can be procedural, but counterclaims is not, which is a bit difficult to reconcile. And I think the definition of procedural seems to be used quite conveniently as to keep a few things on the agenda and to get rid of the difficult agendas. And that makes me ask a question as to, of course, if there are constraints of confidentiality, I can understand you need not disclose. I'm sure there's a drafting committee and who are on the drafting committee. Is it primarily the developed countries who are normally there to get the first draft out, and then the others are there to agree or disagree, which gives a disproportionate amount of influence in the process? I can say that having chaired the drafting committee of the International Law Commission. So what really happens inside the drafting committee, that is inside the working machine? And I mean, of course, things like code of conduct is worthy of praise, but mediation and advisory council. I mean, states are the ones who are spending a lot more money than investors in defending these claims. I mean, it's evident in the costs calculations. So it's a very good idea, but is it going to fly? Or mediation, for example, where these are highly contentious issues where the possibility of mediation is next to nothing. So is there, I get a perception, of course, there are areas which are very successfully done, maybe consolidation would be one in the future. But is a lot of energy being spent on side issues which are not going to be of much help in the long run?
Okay, let me first, I guess, in terms of drafting committee, there is none. The drafting is entirely done by the Secretariat of UNCITRAL. So it does not have, we don't have a committee composed of member states. At times, the Secretariat may consult with other experts within the UN system. So for example, on the sort of the styling of how one might do a multilateral convention, they've talked to the people who did the framework convention for the environment. I mean, they reach out within the UN system, but we have not, at least to date, in that sense, done drafting committees. Drafting committees are something that UNCITRAL has used in the past. From my perspective, for really the reasons that you have mentioned, if we are going to ever do a drafting committee of that sort, it will be open to everybody. And if you'd like to come, you may come. But we haven't actually, and I suspect one of the reasons we haven't used it is knowing the working group, they'd all come. And then it's just really a working group meeting. And so why call it a drafting committee? But we don't use it. We don't use those at all yet. And so we don't have the concern sort of who might be overly weighing it. The way that states feed into sort of what the Secretariat is thinking is through submitting papers in the intersession period, which are published and that everybody can read. The Secretariat reads them, but the drafts that come out are Secretariat drafts. Oftentimes, those drafts will be shared with myself and the rapporteur, Natalie Morris Sharma from Singapore. But we don't extensively comment on them. They are shared so that we know where the Secretariat is going. They are Secretariat papers. On the question of counterclaims, I would say when we talk about the importance of counterclaims and sort of the balance of procedural and not, it does, what we have emphasized is that any system that we develop has to be open to the fact that there may be substantive obligations in the instrument on an investor. And if there is such substantive obligations, then the system must be able to accommodate. So what we have talked about, and there are provisions in the draft procedural rules on counterclaims. What has been discussed is more not about, again, creating what those substantive obligations are, but on the procedural side, ensuring that any system that you design is capable of hearing or responding to a claim that is brought once that obligation is there. So just like we are not seeking to redefine the obligations in investment treaties on what FET means, we have not sought to draft what substantive obligations on investors might mean. They could be put in treaties, some treaties have them, or drafts anyways have them. I'm not sure there's any finalized yet, but the idea and sort of the difference between sort of substantive and procedural there lies in exactly that from my perspective. So the idea that counterclaims could exist, they could be brought. In most of our instruments to date, we have imagined that investor-state dispute settlement might be pursuant to treaties, which may or may not have obligations, but also contracts, as well as investment laws. In the context of an ISDS dispute on a contract, one can very well understand what a counterclaim would be. In that sense, we want to make sure that any reforms that we are adopting can work with those counterclaims, but we have not sought to draft to date the substantive obligations. On the last question about mediation and advisory center, I think it's interesting. I think, in fact, it was two things that were pushed primarily by developing countries, who on mediation felt that there is an alternative to conflictual dispute settlement that has not been fully explored. One of the things that is recognized, of course, in the working group is mediation is not new. I mean, one could have been referring these disputes to mediation before. This has existed. What was interesting for a lot of states was the recognition that that may have been the case, but without some sort of instrument that was adopted, the delegates did not feel they had sort of the underlying authority to bring something to mediation. And so there was question raised, like, do we really need something? There's also other documents in this area. You have the ICSID rules on mediation, the UNCITRAL guidelines on mediation, which were just done. But states really did feel that there was value in having both guidelines and provisions on mediation that sort of lent credence and authority, so that if, as officials, they wanted to recommend mediation, they had something to point to. How much it will be used, I don't know. It hasn't been used much. Either as conciliation at ICSID or fact-finding, these are just not sufficiently used. Could it be used in the future? Perhaps. Should it be used more in the future? The answer to those both might be yes. On advisory center, you know, I actually don't know. I think that the data, at least that I've seen, is that actually typically investors spend more on cases than states, and that's because of counsel fees. States who are were really pushing for this include really least developed countries who would be the primary beneficiaries and see an advisory center who can assist them not only in defending these cases for less, but also assist them with training and capacity building to address concerns when they get a letter making a threat that there's going to be a claim. You know, is this something they should be worried about? Who do they turn to in that? They don't have the internal expertise. They don't have the capacity. And so, I mean, I hear some saying that these aren't sort of the primary reforms. This is where the working group was split. For some, the advisory center was key. This was what they really wanted out of this process. They wanted that sort of institution to be created. For others, this is a nice to have. For some, the code of conduct was, you know, a major sort of the significant achievement. For others in the working group, their view was, it's a nice to have, but it's not really going to change anything, right? This, again, I think reflects just the different experiences that states have had and the different places that they are in evaluating what, from their perspective, is the key reform and what others. I mean, you'll have the European Union who has said before that all of this is nice, but without a court, it doesn't matter. Right? That's their perspective, right? And they raise it every time that it comes up. You'll have others who point out, look, with an advisory center, a code of conduct, new procedural rules, we are a long way to making things better.
Who knows, maybe ISDS itself has not been used for many decades, right? The legal convention has been there in the 60s, yeah. There was a question online, so maybe let's pick 3 comments and questions in a row, and then we will give an opportunity for Shane to respond, or maybe these are just comments which do not require a response. So let me invite Ruchira Bali to unmute herself.
Thank you, Professor Yarrick. So my few comments on the recent proposals that were discussed at the UNCITRAL Working Group in February 24 is with respect to Advisory Center of ISDS. I think according to this reform, more assistance, support and capacity has to be rendered to the developing countries. It is still unclear how this mechanism will be funded. On one hand, it is suggested that the advisory center shall work in an effective, sustainable and accessible manner so as to afford equitable access to financing needs of especially developing countries. But on the other hand, it is unclear how the financing structure shall be devised. And with respect to it, it is also a welcome step to establish the center. It has been provided with a broad mandate, which could be manipulated to either misuse or maybe out of reach of developing or underprivileged parties to a dispute. But considering paragraph 23 of the reform proposal, clarity is to be provided to consider future developments, hence reflecting flexibility. Another suggestion is about limiting the focus of the center to capacity building. and not case-specific services such as representational services such as to be case-specific. This may portray this initiative to be merely aspirational, not yet conclusive of how this effect will be seen. And with respect to it, another thing I would like to comment is about, although much clarity has been provided in draft provision of Article 3, that states and regional integration organizations can be member of the advisory center. However, in limited situations, services can be rendered to non-member states. It could have been broadly defined so as to include individual parties or council or experts seeking funding to make this provision more encompassing. With respect to it, we shall have a reference to Article 6, subclause 4, Article 7, subclause 5, and Article 7, subclause 4, which provides for priority has to be given to least developing countries and developing countries. However, if we include another thing, it's about state-to-state dispute settlement and its budgetary impact under the scope of the advisory center. Although original mandate and focus of ICSID was to deal with cases originating from investor-state controversies, increasing the ambit would not only diverge the focus, but also exacerbate the various budgetary constraints associated with such a move. And this is beyond the mandate of the working group, as it has coverage to deal with cross-cutting procedural issues affecting ISDS and UNCITRAL Code of Conduct for arbitrators in international investment dispute resolutions as were deliberated. I also agree with the suggestion to include a narrower definition of international investment dispute for construing ISDS in a narrower sense so as to include SSG. Priority basis of the deliberation. However, in the reformatory proposal of under paragraph 28 of the draft provision, it is unclear why priority shall be given to investment contracts in comparison to investment code, domestic legislation and investment treaty. There's no clear-cut basis for the priority when the basis of which is to provide legal assistance on disputes. Another final issue is about confidentiality, which can be best addressed by providing, under heading of general principles, the requirement to obtain consent to publicize the proceedings or to hold in camera or out camera proceedings to prohibit participation of public in proceedings so as to ensure the participation should be ensured in if the arbitral decision contains a matter of public importance, the award shall be published so as to ensure consistency and transparency, but also ensuring commitment to rule of law.
Thank you. And can you introduce yourself and where are you from?
Thank you, Professor. My name is Ruchira, and I'm currently a PhD candidate at Lewis University, Rome, Italy, and I'm from India.
Thank you very much. Right, let's go back to the physical room, and we'll have two questions here. So please introduce yourself.
Yeah, I'm Josh Payne. I'm based at the University of Bristol. I had sort of two confined questions about either the multilateral appellate mechanism or the standing two-tier court. First, just understood your comments today as suggesting that in terms of timing, you think the standing two-tier court will actually be done before the multilateral appellate mechanism is discussed. So kind of, is that correct? And then the other issue would be interesting in your thoughts on is sometimes the objection one hears to this, and it was an objection made sort of 20 years ago when appellate mechanisms were first floated in this space, is that, you know, most standing tribunals that exist are associated with some kind of multilateral instrument that at least partly codifies the substantive law that the tribunal applies. Whether you think of sort of ISDS, the International Criminal Court, or the WTO appellate body, to what extent do you think is that a real objection, or is it just sort of something that is thrown up by people who are opposed to the idea of an appellate mechanism?
Thank you.
Yes, my name is Joel Dahlquist. I work for Honor and Porter. I have a question about the working group itself and its role as a deliberative hub. because of the fragmentation that keeps popping up in our discussions as an inherent problem in this field. I think to a certain extent, to a great extent, actually, the working group 3 over that 7 years has grown into the forum that the field has been lacking, not just the 2 annual meetings, but also intersessionals and meetings like this, where states and other stakeholders can discuss concerns and air and draft reforms. It's really only ICSID that could otherwise fill that role, I think. But of course, ICSID is limited to ICSID, to the ICSID rules, and only when they reform those rules. Is it inevitable that if the working group concludes with one or several multilateral instruments, everyone just packs up and goes home, and we are left with a vacuum, and all these personal institutional connections that have been made will just vanish? Or are there discussions about having some other kind of body or forum through which the implementation of whatever these multilateral instruments are can be discussed in the future as well?
Good job. Shane, would you like to respond?
There's
Okay.
Yes, thanks, Shane, and good evening, everyone. My name is Ferris, and I am the delegate for the United Kingdom for UNCITRAL Working Group 3. So I just want to preface that my question is in a personal capacity and is in no way a reflection of UK government policy. And good to see you, Shane, on home turf, by the way, here in London. So my question was, what do you think are the long-run impacts on the relationship between investors and states and global investment sort of trends? I think my question sort of is in relation to how some of the reform options may be argued to risking sort of investor rights like TPF, calculation of damages, counterclaims perhaps. So I'd be very interested to hear, excuse me, what your thoughts are on whether there is a shift in that relationship.
Okay. How long do we have? 11 minutes. Okay. On the specific questions or points, comments made on the advisory center, I think just for everyone, I mean, what was really hit upon there were many of the discussions that we're having. I mean, highlighting the question, of course, how it will be funded. The general structure for everybody to understand as to how it is theoretically to be funded is that there will be recategorizations of states, roughly Annex 1 states who are primarily beneficiaries. Their cost to be members and receive services would be very low, if any at all. There'd be Annex 2 who have more capacity to fund, but also would be considered possibly as beneficiaries, according to the rules on priority. And then there would be Annex 3 states, and those states are the ones who would be considered to have the most capacity to be donors and fund the center. We have tried to move away from politically charged classifications such as developed and developing, because those do bring in broader politics as to who might fit those, and we've tried to shift the discussion to instead be more about what is your need and what is your capacity. And so that's how we are seeking to clarify and classify states. All the questions about non-member non-states participating, state-to-state dispute settlement. I hear what was said, and those views were expressed in the working group as were the opposite. I mean, for some states, particularly on state-to-state dispute settlement, there were very strong views that it should not be included. Others felt that the way to reform ISDS is in fact to move towards more state-to-state dispute settlement. What the working group then decided to do, because it's a useful tactic sometimes, is to kick the football down the field and actually leave this to a decision of the advisory center. In thinking about the advisory center, I think one thing to keep in mind is it is to be an institution. It will be some sort of body, and therefore it is not like a set of rules which one drafts and puts into the world. It will have a governing institution, a governing body of its own, and it has to be allowed some flexibility to develop and respond to the ways that the international system develops and responds. And so there are instances, and that is not the only one, where that goes sort of pushes further down the field. On the question of the timing of the appellate mechanism, the way the work plan was drafted is, yes, that the permanent investment court was to be first, followed by an appellate mechanism. How that exactly will play out, there's a tension there, and I think you were just basically alluding to it. I mean, how do you have an appellate mechanism designed for a permanent court as a second tier unless you've already designed an appellate mechanism? The reason for the two streams, I will say, is the idea that there are a number of states who are interested in seeing a standalone appellate mechanism, not tied to a first instance mechanism. And the why those have been put in separate streams is to make very clear that these are, in that sense, separate discussions. They're the possibility of separate institutions, because we have to recognize, while there are some that are pushing for a two-tier system, there are others who say, I want to retain ISDS ad hoc arbitration at the first instance, but I would be interested in considering being able to sign up to an appellate mechanism that is separate from some other court, and we have to reflect that. So that's why they're done. How exactly that will sort of establish itself in the drafting, I think, still remains to be seen. As to whether standing bodies have to be linked to existing institutions, I think if you are establishing a standing body, there has to be some sort of way in which certain services are provided. What we have talked about in the working group is docking it into and making it some sort of, not a UN body, but UN affiliated in some way, so that you have that institutional link. And so that there would be some sort of background support for it. I don't know that that's entirely necessary. I think you could create an ad hoc body that would be separate from, without standing up a multilateral institution, other than the dispute settlement body itself. I think that could be done. I think that the way it has been done in the past is interesting, but I don't think that necessarily that's the case. But there are, in the working group, perceptions that certain things might be easier if there was an affiliation somehow with the UN, as well as getting the imprimatur of the UN, and that there's value in that. So that is something, even with the advisory center, that is being looked into, but certainly also with the standing mechanisms. On the last point, I think there is recognition that there is value in having discussions continue. And so there are two things that have been talked about in that. One is that if we have a framework convention, there might be some sort of conference of parties in which this would continue. The other is the role of the advisory center in this. And the advisory center does have the two pillars. One is the sort of discussion and capacity building pillar. The other is the litigation defense, the defense pillar. There's been a lot of talk that in that first pillar, this would be conceived of in a sense as the ability for states to get together and to share experiences and to discuss ways forward in that sense. In terms of a body that might be designed to take carriage of the reforms, so that you're talking about, making sure this is, the reforms are living, not just sort of put out there, that's what it is, and in 30 years we'll come back and look. That's where I think you come more towards a conference of the parties that would have some ability to ensure that it doesn't become obsolete. I mean, as Yara points out, it took a long time for there to be any ISDS cases. Now there's a lot. Who knows where we're going in the future on some of this. So future-proofing this and creating some sort of way to make sure that we don't have to come back and do this again and again is certainly on people's agendas. And I think there are two options on the table for that.
Thank you very much, Shane. We still have a few minutes left. If you would like to give us feedback, which we very much appreciate, please use your phone to generate a link and then give us your thoughts. Arman, you wanted to add a few words?
Yes, please. On the question of fragmentation, we're, as ever with international law reform, we're in a sphere of variable geometry. On the one hand, you have the question of individual state consent to any given reform. And so as we remind ourselves, or are reminded, Ultimately, states are per the structure of the multilateral instruments that is under discussion will have the choice as to simple yes or no, whether they want in on a particular reform or not in a protocol. But then on the other hand is the question of what is included in a given instrument or in a given reform where it is a choice as to what is in or out. And there, I think we have more discussion and more debate. But certainly within the context of the multilateral instrument, one of the questions or one of the most significant aspects of that would be automatic amendment of existing treaties for the reasons that Shane alluded to. This is not yet a decision of the working group. It's something we have discussed in formal and informal session, but it's been a few years since we have discussed it. And so necessarily there will be, I would expect, a refresher in September when provisionally I understand we are due to come back to that question. But that will be a far-reaching element of the reform packages. There is also variability in terms of which reform comes into effect when, potentially. So one of the questions on the advisory centre is that, well, if we have a lot of input on that, a lot of momentum in terms of the logistics, could that not be activated sooner? That I gather is on the table now. That could be the case. I'm rather sanguine as to whether that we will get that momentum, not least because I look elsewhere where people didn't expect, we would get cash for X or Y, and surprisingly there are donors or whatever. So that could well be the case. The code of conduct is of course out there as a user-driven instrument already. The advisory centre as well, but the secondary effects are going to be interesting. For me, one of the most significant aspects of that, and that was the case when we heard about WTO advisory centre as well, is fees, council fees. And so there is a question of, to some extent, allowing flexibility, as Shane mentioned, for institutional development. The WTO advisory centre, $400 per hour, does not allow for inflation. So that is the question. We heard about this. So there are some rather important details like that. But its secondary effects on the legal services market will be something to observe. And finally, in terms of, well, our thoughts of generalism versus specific perspectives. As a generalist international, I have a certain perspective. I take a more systemic view of things personally. But a lot of these, as we've discussed, are driven by specific priorities. When it comes to third-party funding, when it comes to counterclaims, and when it comes to security for costs, I'm rather more personally relaxed about them because we went through all that with ICSID. We had them in the amendments in terms of the rules. Those who are in the room, who were present in the ICSID context, will remember, no doubt, very cheerfully, how much time we spent on security for costs and third-party funding. Equally, there's respondents bias on that. So there's more of a chance that we will be able, with those two factors, to get those through. Other questions, assessment of damages in particular, clearly it's a divisive issue, there will be counterfeits, but nonetheless, and this was certainly my interpretation, what happened in the room in September, it got onto the agenda, got onto the discussion, partially as a result of respondents bias. Everyone faces that, regardless of their perspective as to whether they want that or not as a reform. Once it was open for discussion, I was personally very pleased and surprised to some extent to see how some of the states, some of the delegations that were perhaps most opposed in principle to the idea of reform in this area made some of the best comments, I felt, most substantive and rich comments. And so I think we shall rerun that debate, probably. I hope to avoid that, but I think, again, optimistic.
Thank you. Thank you, Armand. A few concluding remarks. You haven't covered one question.
And I forgot Barris's question, so I'm going to come back to it on sort of the long run. Any impacts. So, I mean, I guess I would say a couple of things here. One is we have, in terms of the impacts, we do have to recall that this was, the ISDS mechanisms, this is something that was created by states relatively recently. We're talking about, yes, it's been around for a long time, but the cases really start to explode in the 1990s. So we're talking 20 to 30 years of jurisprudence. In that sense, I don't think it should be surprising to either states or investors that states are now sitting back to ask themselves, is the system that we created to resolve these disputes fit for purpose? Is it actually serving what we intended it to do? And I think that that's the moment of reflection we are in. And we do have participation from investors groups there, and most of them actually also see a need for reform in this area. So then the question becomes, okay, well, what is your reforming? And this even picks up something a little bit on what Arman was saying about respondent bias. There is sometimes a tendency, particularly for those states who have consistently been the respondent, to see this world through respondent's eyes. That I think can be balanced in the room, not just from an investor's perspective, but there are also a number of states, and of course Canada is one, that where they have been a respondent a number of times, but also have investors who consistently use these treaties. For those states who have consistently seen themselves as only respondents, I think one thing to keep in mind is the world does change. What we are seeing in a lot of treaties now, actually, is that they are between least developed countries or between developing countries. As investment flows sort of alter and change, where you now get more investment moving from some countries in the past that would only been capital importing, and now as they develop, they become capital exporting in their particular region. So you're seeing this in Africa, where there are a number of treaties coming in, and you're seeing countries such as Nigeria, Morocco, who may have been traditionally capital importing, now begin to occupy both roles. And so states, in thinking about what the reforms are, do have to be acknowledged that they do need to wear both hats. This is not, these reforms are to make this system fit for purpose. They are not defensive tools in litigation. I would say the other aspect of that, in terms of sort of the long-term focus, what's been interesting in the room is the acknowledgement from pretty much all states that investment is going to be necessary. Investment is necessary, and foreign investment for least developed countries, for developing countries, is necessary for them to reach the sustainable development goals. It's going to be a critical part of the green transition to a green economy, that investment is necessary. And so there can be, for states who consistently see themselves as the respondent, there can be almost the sense that this the relationship with investors is necessarily an antagonistic. And I think that for the reforms to be truly successful, it's going to be important to move away from that antagonistic perspective. And it can be easy to slip into, particularly for those of us who are litigators, like yourself, and that's what you do. But to remember that, in fact, for the vast majority of investors, and maybe not all, but for the vast majority of investors, they don't want an ISDS. They want the investment. The state wants the investment. Yes, there are issues that can arise into legal disputes, but we want to avoid trying to see it as an antagonistic relationship and rather as a partnership. And then the question in seeing it as a partnership is, when disputes do arise, do we have a system that is fit for purpose to resolve those disputes? And that's, to me, where the reforms hopefully will be most successfully headed.
Thank you. Thank you very much, Shane, for sharing your observations, your forecasts. I hope that those of us who are optimistic will see the reform happening and actually implement it in practice. I think the UNCITRAL arbitration rules were a great success, yeah, no doubt about that. So the ISDS edition hopefully will have similar success. And in Vienna, in New York, you probably gather the highest number of state lawyers interested in ISDS in the world. But here in London, we actually have hundreds, if not thousands, of lawyers who do this sort of work on a full-time basis. So those law firms, those individual practitioners, academics, barristers, who are members of the Investment Treaty Forum, and also those who are part of bigger ecosystem of international law, investor-state disputes, public international law more generally. So I hope there will be continuation of this conversation in the future. Our next conference, which is already planned, will be on the 8th of November 2024. It will deal with illegality in international investment law. We also here at BIICL are organizing other events, smaller events, also a couple of events this summer. This is something new. We do a summer course on public international law, and our other courses are quite popular with government lawyers, particularly after Brexit, when public international law has become more relevant. In the past, much of it was done from Brussels. Now many things have moved here. So I hope to see you and other participants whom I also thank for their contributions to this debate, and enjoy this evening. We'll have a mini wine reception hopefully here in a couple of minutes. Let's give a round of applause to all those who have contributed.